Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
So, investor agreements. Investor agreements sound great on paper. I've had more problems with investor agreements than anything. They're a great way to infuse capital. Okay, so what happens is I have a business that's distressed, and I happen to have that friend that's got money. And they've always wanted to be involved, okay? So a lot of times it could be restaurants, it could be, it's really any fun thing that you have, okay? So anybody's in a fun business, I'm not in a fun business. So people don't want to invest in my business. But if you have a fun business, people have always wanted to do your business, they just didn't want to bear the risk of it, okay? So they want to invest. I'm going to grow with you, okay? What they don't understand is investment means you aren't getting your money back, all right? If I have financial problems today, it's not going to get resolved in 6 months because you just infuse some money in, okay? So that's why they're fraught with problems. They take a lot of time to make sure all those things are taken care of, okay? It's the voting control that's the big deal. An investor, depending on the investor, will want to come in and fix your company. That's a disaster waiting to happen. You always have to maintain the voting control. If someone comes in, unlike Shark Tank, where they want to take over that controlling interest, you can't Shark Tank it, not in a small business, right? So you have to make a decision. If they want your control, then you're looking at other sell options, not that, okay? So that's kind of your big issues you're dealing with. Here's another biggie people forget. It's actually potentially subject to securities laws. What does not apply to securities laws is when I'm selling my interest in a company to someone else, okay? So I own my practice. If I sold my practice to someone else 100%, that's excluded under law from securities, under Illinois securities laws and under federal, okay? Because I have a right to transition my interest. But if I bring in an investor in and they're not buying an interest, they're just buying in, there's potential securities issues. Now, there are a lot of exceptions for small business owners. I don't want anybody to be panicked. But what if you didn't pay attention to this? Now, all of a sudden, that money that you were supposed to invest, say someone gives you $10,000, okay? And you're like, that's great. That'll help me through some stuff. And you're thinking, what's the big deal? Worst case scenario, I got to give them back 10 grand. But now all of a sudden they say, you know what? You've defrauded me under this. I'm going to sue you under the securities laws. And now there's attorney's fees and penalties that all go there. And your $10,000 investment that you thought was just going to help you out became $100,000. And that's what you're going to be very careful about. So if you have investors, you cannot do it yourself. We have so many people that do it. Yes, sir. Okay. It makes it very difficult to sell the company later on. If I have an interest, and let's say that I've gotten in a couple waves of investors in there, they have rights just like anybody who's got the operating agreement and the shareholder agreement, right? Because you're going to bake them into your agreements. So even if they got like a 1% interest in that, you still have to notify them, okay? And depending on how you structured that, they didn't want to get sold out from under you. What if they told you, I'm going to invest in your company, but you can't sell it for the next 2 years? And you had a banner year, and then COVID hit. How many people had banner years in 2019 and 2020 was going to be their year? And it wasn't. But they couldn't sell, okay? I know some people did actually really well selling their business in COVID. They were really smart, okay? But sometimes people couldn't because of these situations. So that's the thing. You got to be very careful. Sometimes the smallest problem can just, they can muck the whole thing up. Okay. So the positive side of it is that these agreements can be flexibly tailored to waves of investors, what they call tranches, right? You can get in waves of money, but keep in mind, every subsequent wave wants the same protection as the earlier ones. The earlier ones don't want to be undermined by the later ones. So what happens is that my fees go through the roof sometimes. So the other part of it is employee stock options. Now, this is not an ERISA course, okay? But sometimes ERISA can play into this, depending on the size of the company. We're not even going to start touching on ERISA, and it's just because employee stock options do fall under that. So if you have something like an ESOP and ESOP, those types of things fall outside the scope of what we're talking about. They do come under certain regulations. You got to be careful about that. Okay, we're just talking about a situation where someone wants to buy your company over time, your key people, right? They want to give you 5% as a bonus, those types of things. Okay, So they can be accomplished by employment agreements which reward stock over time. That's the easy way that you do it. Employment agreement, Joe's my manager. Joe's been doing an amazing job. I want to give Joe 5% of my company. I give Joe 5% non-voting stock, but it's only good for he stays with me for 5 years, and then after 5 years it'll vest. If he leaves my company in 4 years, then he doesn't get anything. That's your typical situation. So those are completely fine. When you're bringing on people in your company, you want to retain control, I would say 9 times out of 10, that's kind of what you're going to do, because you need to give them some skin, but they don't really have anything to give, but you're going to get their sweat equity, and there's an importance to that. They do have bonuses, so you're getting to a point where you're starting to pay them a lot of money. So there is something kind of sitting in the till for later on that you can play against it. So let's say that Joe's had this really great year, and I have to pay Joe $50,000, okay? And I'm like, I really don't want to pay Joe $50,000, but I want to lose him. I'm going to incentivize Joe to stay on and take a little bit less so that he can build with the company, okay? I say that only kind of half jokingly because like we know, a promise of a future, we don't know how it's going to be. But you obviously value Joe and you hope he's going to grow with you, so that's how that's going to play out, okay? So like I said, there are great ways to incentivize employees. Be careful about the overpromise though, okay? Most of the times these things are set out over time, and if you're not careful about your time horizons, you might mess up. I've had a couple times where people have put, say, a 3-year time horizon. They didn't want to leave the company in 3 years. Sometimes they wanted to leave the company on the other end in 1 year, okay? So you got to be very realistic. It takes more time to think about. Just in the same way as I said you have to negotiate those situations with your employees before, where you have to take extra time to make sure they understand. Sometimes you got to think about it, because a lot of times when these deals are going on, we're really kind of at our retirement age, or retirement age really isn't even a true statement anymore. You're ready to move on to something else with it, right? Maybe you want to kind of step back. You're working 15 hours a day, 20 hours a day. You're doing everything. You're like, I can't do this anymore, right? I can do the stuff that I'm really good at, but I need somebody behind the scenes who has a little bit more energy than me. And you want to get out of it right now because you're doing it all. But now suddenly Joe is my example. Joe starts taking over. Joe's amazing. In 2 years, I was like, if Joe were here 20 years ago, I could just keep on doing this, and I don't want to get out. You have the Brett Favre syndrome, right? And you're crying, and you're like, I can never get out of football. Hello, Vikings. So I'm just saying, we all have that situation. Yeah, exactly. All right, so you got to comply with the shareholder agreement, operating agreement, even with those situations, because they're stock options, right? If it's you, it doesn't matter. But if you got another owner in there, bringing somebody on, you are giving them an interest, okay? Even if you're adding stock. So sometimes people think, well, we're really just going to add on some stock. You're diluting someone's interest. 100%. Math doesn't change just because you have an agreement, right? 100% is still 100%, no matter what that is, okay? So here's the common steps in a sale. So these are basically the 5 basic ones I go through. Okay, we got our non-disclosure agreement. If you go into the sale of a business without a non-disclosure agreement, bad. Okay, you might as well give up your company. You might as well tell somebody it's for sale and let them just open up your books. You got to do these. These are like boilerplate. Okay, we have these sitting in our computer. It doesn't cost anything. I mean, it does, but not relatively speaking. Letter of intent. So letter of intent, sometimes banks will say, what's your letter of intent? And there's terminology in our business that people, like we were like, oh, it's a this, Like if I said, I want to come in and get an oil change, like that's nothing. But to me, I don't know how to do an oil change, and maybe that's a big deal. Letter of intent is my oil change, okay? A letter of intent is like just a routine document that sets forth things. But if I've already moved on to the next step and I'm doing, something bigger, I may not need a letter of intent. Why do you do a letter of intent then? We're going to talk about that, but the primary thing is that I don't want to spend a lot of money on big agreements and that if it's not going to go anywhere, okay? So my non-disclosure agreement, make sure they don't steal my business. My letter of intent, make sure that I've kind of identified the deals. So when they lowball me and they tell me that my $2 million company is worth $20,000, I'm like, okay, well, I'm glad I didn't waste too much money than that. That happens all the time. I mean, that's really an extreme example, but people lowball all the time, right? And so that's just the way it goes. Your purchase agreement's where all the work's going to be. That's where that's the nuts and bolts of everything that's going to be contained in there. You have your due diligence. That's actually on the lawyer and accountant side, financial people, the bankers. That's where all the work is being done. You have to do due diligence. The only exception would be is if someone's been in the company, like if my CEO or my CFO is going to take over my company and they know my numbers, maybe I'm going to waive due diligence. Or if I have a distressed piece of real estate, using that example, and it's just sitting there, I'm going to bulldoze the whole thing. Maybe I don't care about due diligence. I might worry about environmental concerns, but otherwise, so you can limit that. But for the most part, for a real company that's operating and people care, there's going to be a ton of time spent on turning over a lot of data. Okay, and then there's the closing itself. Closing is actually the easy part. These days, a lot of time, and it's funny I say that because by the time you got to the closing, hopefully you just have your documents, you're being done. Stuff does happen at the last minute, right? I mean, I'm not saying people don't scramble, but what I'm saying as far as you shouldn't be negotiating a deal at the close, with the exception of some minor issues, which we'll talk about. Okay, if you're negotiating major issues, you're just not going to close on your deal. Okay, so non-disclosure agreements, what are they? So main thing is protects the disclosure of the sale itself, okay? That's why you have it. You don't want anybody going out of the market saying they're going to sell. You're going to be disclosing parts about your business. You're going to disclose the good, but actually what you're more concerned about, you're going to disclose the bad, right? I mean, that's just the way it is. All of us wish we made more at what we do. We know we value our time, but we're slaves to the economy and everything else that goes with that. There's not much we can do about that, okay? So you want to protect that. Protection of confidential information. What's my confidential information? Pretty much everything that's in your computer right now. Your customer list, your financial information, your business models, your marketing. All of those types of things are confidential. If I have a patent, all of that information that's contained within there, you want to protect that. The way that you do things, you have drawings, right? Maybe I want to find out how big you are. Maybe I'm actually not even interested at all. I think you're really good, your reputation is great, but I want to see if I can actually open up next door to you and you can do anything about it, okay? There's all kinds of reasons people want to look. Non-compete language. There is a non-compete built into them that says you will not compete against me for a period of time, just like their employees, if in fact you don't go forward with my deal, okay? I know there's a lot of changes in non-competes in the last couple of years for employees. Those rules do not apply to business deals. So business if you sign a non-compete in a business deal, it's enforceable. Why? Because there's true consideration. You've given up confidential information, which has value, as opposed to an employee who comes and works for me for minimum wage. That's different, right? That's a completely different relationship. Trade secret information. So trade secrets actually defined by the law. The Illinois Trade Secrets Act protects your interest in certain information. And you don't even have to have a non-compete, just so you're aware. So you actually if you ever wanted to enforce against somebody on true patents, those types of things, just realize even in the absence of an agreement, you have protections under the law. But you want to build those in. You want to identify what it is. So if I have a particular, I have a marketing system, or I have a branded something that I provide, okay? So let's say that I set up some great estate planning thing and I've organized this all great and I'm giving it to everybody and now they can come in and look at that. Maybe that's a trade secret because it's something I've protected, okay? Or it could be a technology. And this is another thing that's important, is it includes exclusivity periods for evaluation of the business. Now, why do I say that? You can do it either way. Either you can sell your business on a non-exclusive basis saying, look, you can look at mine, but I'm gonna put out the market for anybody who can come and get it. That's fine. But a lot of times people are gonna wanna lock it up so they can look at it. So you tie that in there. There are options that are sometimes paid. You can ask people to pay you money in order to have the opportunity to look at your business. It's not every agreement has it, that's negotiated, but just keep in mind that you can get money for just the benefit of looking at your business, especially if you got a long-standing business that you're the only game in town or you're one of the better games in town. You definitely want to take advantage of that because honestly, just by virtue of the fact they're talking to you, think of yourself as basically being a mentor for the day for them. You're still giving them value because you're telling them how to run your business, okay? And then this is binding on the party, so keep that in mind. There's some things that we're going to talk about that are not binding. These non-disclosure agreements are in fact binding agreement because every part of them protects your business. So these are going to be binding, okay? And it cuts both ways. So letters of intent, these set forth the basic terms of the deal. These are your term sheets. Everybody in a business, you guys have some type of a contract that you give to the customer where you spell out what you're going to do for them as services. That's your letter of intent for this deal. It's the transactional equivalent of that. It's spelling out what's going on, except it's got legalese in it, okay? So the benefit is that you're going to save money in the deal, right? The amount of time that you put into a letter of intent, even if you could have put a couple hours into it, it's better than what you're going to put into a full agreement. You're going to find out real quick if it's a serious deal, okay? Sometimes people won't even sign the letter of intent. In fact, a lot of times they won't because they're just trying to fish. They're hoping that you're going to kind of rush it and you're going to get stuck. This allows you to really slow things down really quick and just not waste your time. It can and mostly does include the same protections as the NDAs. So you'll have your non-disclosure agreement, your letter of intent will also include other restrictions that are going to be because all those terms are going to make it into the ultimate agreement, okay? So this next part where I say it's often non-binding but can be binding, so the same things that you find in non-disclosure agreements are going to be the binding parts of the letters of intent, but there's going to be other aspects that are not binding. What are the not binding? The fact that I actually have to close on your deal, that I got to pay you money, those types of things. Those are the non-binding aspects because we're still feeling out the deal, okay? These are not necessary if you've drafted an agreement. So I said before that people kind of make more of these than they need to. If you already have gone forward to a contract and you have a purchase agreement, you don't need a letter of intent because you've already done it, okay? Sometimes, so the reason I was talking about the bank's going like, where's your letter of intent? And you're like, well, we got a purchase agreement, but not the letter of intent. Oh no, we messed up. No, you didn't. It's just they're using lingo. You know, it's like they're going through their own checklist, okay? So if you've already gone ahead of the game, this is just, it's supposed to be a time saver, frankly. Okay. So the purchase agreement itself, this is going to spend a lot of time to go through it, okay? All the terms are in there, not some of the terms, not maybe, all of them, including things about loans, including things about liabilities, including things about employees. Everything that's going to happen in this deal is going to be spelled out here. There are going to be what I call ancillary documents later on, other documents that flow from this, okay? You can have in a basic agreement that could be 15 pages, and the exhibits could be 100 because of what it is. And I say that because you have all these side agreements that are baked into it, okay? So, you know, when people are like, I want to have a simple agreement, your deal would have to be simple. If your deal's complicated, it is what it is, right? You just want to have the thing taken care of. So the price, obviously that's there. Price, we could spend quite a while on a price. A price can either be a dollar amount, price can be over time, prices can be tied to receivables. So there's times where people say you're going to pay me a percentage over time. You do that with books of business, especially like ones that are volatile with renewals, those types of things. You might have it based on that. Products where you have like situations where you might have bad batches, those types of things. When you have more routinized type of businesses, so if people come in, you do the service and they pay, you're usually going to have a price, right? Because it's going to be the same every year. And the owners or the new owner is going to bear the risk, right? So if you had a banner year, obviously you're going to sell hopefully when you're at a high. And if you had a bad year a lot of times people don't get into those deals where they're like, I'm going to do it over time based on how we sell. Unless for you, it's the way to sell the business, right? So sometimes the only way you can do is you're like, I want to get a decent price now, and then I'll tie it to that growth. So the price can look all kinds of different ways depending on what you're trying to accomplish. The asset and the membership interest are what are spelled out there. What are you actually transferring? The contingencies, this is a big deal, okay? If you mess up on the contingencies, you mess up your deal, okay? And the reason is it gives either side the ability to back out. If one side doesn't comply with something, okay? So if I think about a manufacturer that has a huge warehouse and they have trucks and a bunch of other stuff, all right, I have real estate concerns, I have the warehouse concerns, I have liability concerns, I have DOT concerns, all kinds of other things I have to worry about. When I'm acquiring that business, I need to make sure all that stuff is going to flow, that actually all the stuff's going to transfer to me. Those are my contingencies. As the seller, I need to make sure that you can actually qualify. I need to make sure that you can actually pay me. All those types of things. So those are my contingencies. They are as unique as the deal. There's some kind of basic ones, but like I said, there's a lot. So a lot of times when we get involved, like our value is actually talking about the contingencies, making you think. I'm working on one right now that they want to rush the deal. And I asked 3 questions about, kind of liabilities and contingencies. And I was like, oh, never looked at that. And I said, well, you're not going to rush your deal. Because if you buy this business, you're sunk, right? So those are the types of things you've got to be really aware of. Assume contracts, leases, and liabilities, another huge thing. You need to know the accounts. Oh, he's good, no. However you do it, even if you have people in a database, all those accounts have to be evaluated. Why? Because you don't want someone later on saying you didn't tell them, right? Everybody needs to be an open book situation. The leases, obviously, you can't just say, I'm going to lease my space. What if your landlord has a provision there that says that you can't assign it without their consent, and it can be withheld in their sole discretion? And guess what? The reason that you want to get out of this business in part is because you have a terrible relationship with your landlord. Guess what? They're going to jerk you around. And all of a sudden you're going to see costs. Well, in order to evaluate your deal, we're going to have to do it. Here's $5,000 for the lawyer. It didn't cost $5,000 for the lawyer, but it will for you because they want to mess up your deal, okay? Franchises, that's another big deal, right? How about you got a franchise? I want to sell the business. It's not what they told me it was going to be. You got to comply with that stuff. Your buyer's got to actually be good, okay? And then the other part of it is, of course, there's bankers who are involved. You have to make sure that they've actually seen the documents. A lot of times they'll put the brakes on deals because they won't help you, okay? And then of course it sets forth your closing date, which is either fixed, but a lot of times it's fluid. It's either one day, or what it does is it extends it out because of certain contingencies that might happen. So for example, we're going to close 30 days after the contingency date is closed, our due diligence date closes. Okay, these are all binding on the parties. The entire contract's binding on the party, subject to contingencies. So what does that mean? If the deal's not going to go forward, then of course it's not going to be binding on the parties, except for certain things like confidentiality. There might be non-compete provisions in there that would be tied back to the NDA. There's going to be, obviously, you don't want them disclosing the fact that there was a sale. There might be earnest money. So for example, most deals, we're not really spending any time on that because everybody understands earnest money, but basically the money you put down, maybe they get that back, those types of things. Okay. So people are like, do you have a form agreement in your system? Of course, I have form agreements for everything I do. We all have form something, okay? Your deal is not going to be treated like a form agreement. It shouldn't be, even if it is a routine deal. Why would you want a form? You want a form if yours is routine, that all the basic stuff is in there. I don't want to spend a lot of time inventing your deal. I want to focus on the business aspects of your deal. So my final point here is, don't use an internet agreement to save cost. You won't. If you give me an internet agreement, I will redo your agreement. If you make me correct your agreement, it will take me 3 times as long. Those 400-page agreements, and I'm being funny about that, right? The really long agreements that you don't want to sign are the ones you want to sign. Why? Because the attorneys are used to seeing them. We'll take no time looking at them. I'm looking for paragraph 15 that I've seen 100 times over. When you get a 30 or 40-page lease, how you regret looking at that, or you know when you're in construction, you have like these big contracts that they come and you're like, I hate these. But in my world, what's big is sometimes easier because I see it in its format. I'm like, I know this exact contract because I've seen it before. That's what you have to understand. It saves time. So don't try to save time on a simple agreement. It's not simple, okay? And plus things get missed. That's the problem. You got to make sure that you have all the stuff in there. So on the due diligence phase, so what are we going to look at a due diligence? Again, we're going to spend a ton of time. The phase where the buyer is evaluating the business, okay? Everything you have is open, no matter what you think. Everything that you have. The stuff that you have to dig back through the boxes because your system's a disaster has to be gotten. Your corporate books that you didn't do have to be created. All of the stuff that you've been waiting for a long time to deal with because you just didn't have time, you're going to find that you have to have time. The only way you're going to get away with that is if let's say your company it's really disorganized and the buyer really, really wants your business and they're just going to take it sight unseen. It's kind of like if I went and I wanted to buy a house that's on the east side of Aurora that's been sitting there for the last 5 years and no one's bought it, and I'm going to get a discount price on it, right? I don't even care. I don't care if it's shot up on the inside and all that type of stuff. If your business is like that, and I only say that because sometimes you do see businesses like that. Sometimes there's actually an inherent value in the business because it's unique or something that the person doesn't care. Okay, maybe your due diligence looks easy, but for most people, how you do business matters. Why? Because they're buying your business. The more organized it is, the better. So really, sometimes the meetings that you have up front, when you're having these discussions about what you should do with due diligence, is advising you about what you need to get fixed in your business before you actually go out to sell. It's kind of like when a realtor comes to try to sell you your house, right? And you really love those orange walls that you put down in the basement because you love orange, except no one likes orange, right? It's that kind of a thing. It's just the little pointers, okay? So appraisals of the business, everybody's like, I don't want to do an appraisal because it's expensive. Yes, it is, okay? Appraisals are a lot of money, okay? There's a reason that they're a lot of money because they're evaluating your specific business. But if you're serious about selling your business, if you don't want to get lowballed, you have to have an appraisal. If you're worried about it coming lowball, okay, then you may have to get more realistic about the business, okay? Can you do sort of second tier appraisals? Can your accountant give you some numbers and that kind of stuff? Sure, of course you can do all kinds of things. You can even reach agreements. No one has to do an appraisal. But if you do it, just spell out what you're doing. That you're just not going to make the sale of your business contingent on that number, okay? Your accounts. That's a big, broad category of all of your business accounts, all of your contracts, everything that you have that goes in your business, every purchase order that you have, your customer database, how much money you're making, all those things, those have to be disclosed. Your employee payroll issues, okay. If you have trouble making payroll, I'm sorry, but it's going to be found out, okay? Everybody has payroll issues. When people look at these things, they're like, I don't want to disclose that. It's embarrassing, okay? Businesses are volatile. It's just the way it goes, okay? There's a reason you're selling your business, sometimes good and sometimes not. You got to expose all those things. I'm going to talk to you about something about the state requirements. The state cares about this too, because the state wants their contribution. So if you didn't pay the state and you didn't deal with it at the transaction side, Once we go to try to close and I have to ask the state to give me a clearance letter, I'm not going to get it. So might as well kind of fess up. Your tax issues, they matter too, okay? If the IRS gave you a notice, you're not closing right away. You're just not. The IRS owns you, okay? The IRS, we know this, right? The IRS has a priority lane, and no matter what area of law that there is, the IRS sits on top of the world, okay? So if you have a distressed business where you have a state or a federal lien, you have to deal with it, okay? Asset sales might work depending on what you have. Like say there's no money being transitioned, but you need to have your customers handled. I'm not saying you can't deal with it, but you just can't have cash exchanged, right? So sometimes there's issues that occur. Sometimes you have a situation where the person will buy you, and then you'll have that transition agreement where you work for them for a while, you know. It is what it is. Lease and property issues, obviously if there's any real estate that's involved, whether from a lease or a buy, that's huge. Sometimes the business transaction looks more like a commercial real estate deal, honestly, because that's what most of the issues are, especially environmental issues. So, you know, one of the industries that we represent would be trucking companies, okay? There are use issues that happen where you can't bring in the traffic on certain major roads. And if you don't look into those kind of things, you think, oh, it's going to be great, this is the perfect size and everything else, and you'll find out, guess what? My trucks can't go in egress and ingress. It's just the way it is. So every business, or you think about, you know, what if you're leaking things like oil, or if you have situations where you have like things that have to burn in the back, all kinds of things that you have to do, you have to be careful about those, okay? So we work with companies in all these areas that we trust, so the nice thing is that when you work with somebody who does business stuff, you don't have to think about those things. We will hire experts that we think are good to get you good reports. Luckily, the thing is a lot of times you have to go offline and have discussions with them. I don't want the environmental report killing you. So the people that we work with will usually call us and say, hey, by the way, before we prepare this, here's what we're seeing. Okay, so there's a lot of kind of things that go on that you can work out, but once that stuff's disclosed, it exists. So an environmental report done on this deal, if it doesn't close, it follows you to the next deal, because they're always going to ask a question, did you do it? So that's why the letter of intent and some other things are important early on, because if you think this is going to be too problematic of a deal, it's better to kill it then than to get to the point of due diligence, because by then you've done some work and it's a problem, okay? Financing issues and lender review, again, huge. We don't control that, they do, okay? So the finances and the lenders, I mean, whatever they tell us to do, they do. If we want to close our deal in 30 and they tell us it's going to be 120, it's 120. It's just the way it goes. They're going to show, you know, so I think sometimes people think they have more control. Oh, I know the president of the bank. I know presidents of the banks too. We all know presidents of a bank because they're small banks. That doesn't mean anything. You know why? Because they have underwriting requirements and they have to answer to somebody beyond themselves, which is means that they don't want to go to jail, right? So I'm saying there's controls, and so I have to actually, luckily I'm at a point in my career that I can say no to a client, but I remember being younger, like it intimidates you. You're like, oh no, they think I don't know what I'm doing. You gotta just say, look, you cannot do what you want to do. It's just the way it goes. Governmental compliance, variance, use issues, which I was telling you, like the trucking example. I mean, you got to comply with those. So if you don't have these issues, consider yourself lucky, because the sale of your business will be easier. But if you have a lot of these issues, there's really not a lot you can do. You know, sometimes these issues can spill into labor issues. You know, you can have issues about union contracts. You can have issues about Prevailing Wage Act issues. You have governmental projects that you're working on. You have certified payrolls and other. So keep in mind, some of these issues do spill into other areas of law that can complicate it, okay? So just remember at the end, the buyer can exit the agreement, usually if one of the contingencies doesn't apply, subject to maybe earnest money and some other things.
Thank you again for watching this informative session. If you have any questions about what you just heard or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.